May it please your lordship.
One or two orders or anything.
Lord, I seek your lordship indulgence to list, my lord, this is a writ appeal, my lord, which is in the process of file.
Sir?
I seek your lordship indulgence, my lord, for listing this writ appeal, my lord, on Monday. There is a sense of urgency in this case.
What is the urgency?
My lord, what happened here, your lordship? I was settled with a check gate cum waivage by the government. And there is a statutory rule which is holding the field. Now that was for 3 years, your lordship. Now, my lord, due to expire next year. Due to expire next year, my lord, the term will continue till next year. Now what happened, your lordships? They have issued an impugned order saying that last year they have issued an impugned order saying that the term is only for 1 year, due to expire sometime last year. So in the situation, my lord, I filed challenged the impugned order before the learned single judge. The learned single judge, my lord, after hearing the parties, my lord, granted an interim order. So interim order was continuing, your lordship. Now during the last vacation, what happened, my lord? They had withdrawn the impugned order. So by implication, my lord, they have restored the original, my lord, lease agreement.
Once the order is withdrawn, the issue has become infructuous.
Exactly, my lord. Become infructuous and the original agreement has been restored, which would continue till next year. So that was the situation, my lord. But unfortunately, my lord, on the 1st of February, what they did, because this is an enforcement, my lord, check did come way breach. Because there are the state government, what the state government do, my lord, they use the way breach.
Give the number. It's already been filed, you are going to file.
In the process of being filed, your lord.
Monday. Which otherwise, registry is directed to list the matter if it is otherwise in order. You're going to file it today.
Today, man.
File it or going to file?
In the process of being filed, your lord.
Also. Normally, yes, let it come up on Monday. Yes.
From the daily list, item number 1.
I think my brother has passed on.
May it please your lordship. Lordship, item number 1 and item number 2, lordship, these 2 items are wrongly listed before this honorable bench, lordship. Because the judgment in the writ petition is...
For the alternate bench. Item 1 and 2.
Yes, lordship, 1 and 2.
Yes.
I am appearing for the respondents, your lordship.
It has got to go before some other bench.
Yes, my lord. Let it come in the first week of March, my lord.
When do you want?
First week of March, my lord.
First week of March. But it's for admission. Admission is between the appellant and the court. You are entitled to oppose the interim order.
My lord, that is
you can't choose a specific date. Suppose we are going to give an interim order, then you can oppose it at that point of time.
My lord, if possible, my
first week of March.
First week of March.
First of March or first week of March?
First week of March, my lord. Any date, first week of March. Tuesday,
Wednesday, Thursday, any day.
Highly
the request of the respondent. But we can't say the request of the respondent.
My lord.
First before the alternate bench in March. In which so also is not a party.
Yes.
Yes.
Item number 3.
Highly appreciated.
My lords, in item number 3, I appear for the respondents.
Yes, madam.
So this is, my lords, this is an application under 5 for condemnation of delay.
How many days delay? How many days delay, madam?
My lords, in the application, the delay in the prayer, they have stated it is 99. But the delay actually is for 217 days.
Lordship, if I may.
You are appealing to the respondent.
Appellant, Lordship.
Appellant.
Lordship. The delay The actual delay is, Lordship, 107 days, Lordship, but
107 days.
107 days. Inadvertently, Lordship, I beg Lordship's forgiveness. There has been some inadvertent typing error, Lordship. Instead of
Do you have
107,
any objection, madam, for the delay being condoned?
Yes, my lords.
Do you have any objection for the delay being condoned?
My lords, in the application, they have stated that the order of Honorable ITAT was passed on 12/12/2022,
Yes.
and they have received the order on 31st of March 2023. Whereas, my lords may have our counter that we have filed. We have stated that in paragraph number 5, that the order is set to be received for the purpose of 260A on the date when the order is pronounced. The order of
Where have you stated, madam?
my lords, in the counter affidavit. We have filed the counter affidavit.
Petition. Affidavit. This is your counter affidavit.
Yes, my lords. If my lords may have the counter of, we have stated that the order of ITAT was pronounced in open court on 12/12/2022.
Yes.
Whereas in the application, the appellant has stated that the order was received by Principal Commissioner of Income Tax Shillong on 31st of March 2023, and therefore, according to the appellant, the period of limitation is up till 29th of July 2023. It is their submission.
120 days.
Yes, my lords.
Ah.
And then subsequently in the paragraph number 3, they state that the approval for filing the appeal was received only on 14th of August 2023. So, my lords, there is a delay as far as the days from 31st March till 2023 till 29th of July is concerned. And also, it is our submission, my lords, that the order of ITAT, when it is pronounced, it is deemed that it was received on that day to the appellant. So, my lords, the delay.
The delay, though the period of 120 days is there, the delay from 29/7/2023 to 14/8/2023 allows to be explained, is it not?
Lordship.
Yes, my lords.
The delay from 29/7/2023 to 14/8, because they have got a statutory time limit of filing an appeal, which is 120 days.
Yes, my lord.
So beyond that period only they have to explain the delay. They need not explain 20 days.
But my lords, the order was pronounced on 12th of December
But any of
2022.
you have a serious objection.
My lords.
Delay being granted. We'll consider on merits. We'll consider the case on merits.
As my lords may deem fit.
Though the respondent has stated that the order of ITAT was pronounced on 12/12/2022, which was said to be received on 31/3/2023, as the appellant has not preferred an appeal within the statutory period of 120 days, there is a delay in filing consent appeal, and that there is no proper explanation for filing an appeal. Stop. According to the respondent, the petitioner has stated that the approval for filing an appeal was granted on 14/8/2023, and that on account of preparing the appeal and getting a final approval from the office of the Chief Commissioner of Income Tax, the delay has crept in, and the delay of so many days need not be condoned, as there is no sufficient cause given by the appellant or petitioner in preferring the appeal. Full stop. So, from the pleadings of the petitioner, the petitioner has submitted that approval was accorded by the department only on 14/8/2023 for preferring an appeal, and thereafter it took time for drafting the appeal and getting the approval of the income tax department, and that there is a delay and there is no prejudice is going to be caused to the respondent if the main appeal is taken up for hearing and a finding is rendered on merits. To stop. Finally, the respondent would submit that the court may take, the court may condone the delay. However, the liberty may be granted to the petitioner, to the respondent to oppose the appeal on merit. To stop. After hearing both the parties, we are of the view that there is no need to explain the delay of 120 days, which is permissible under law, and that the delay has got to be explained beyond 120 days. We are of the view that the respondent or the petitioner has given some reason for condoning the delay, and that in the light of the judgment of the apex court, so and so, if the delay is short and there is no proper explanation, the delay need not be condoned. If the delay is enormous and sufficient reasons are given, delay, so the judgment portal said, delay can be condoned. In the present case on hand, the delay is short and reasons given are acceptable to condone the delay. Delay is condoned.
I love my lordship.
Your Lordship, on the issue of notice,
Sir?
Your Lordship has issued notice on the issue?
No. Now the number, it will be numbered.
No,
Thereafter will come up for admission. Thereafter we will order notice.
Okay. Yes, that's
Yes.
I have no issue on direct acknowledgement, but then I will like to
Yes,
argue.
yes.
Oblige, Your Lordship. Oblige.
Yes.
Item number 4.
Very nice of you in allowing your junior to address the argument.
I know, yes. I know that. Thank you. Oblige.
So this is one way of encouraging the juniors.
Yes, yes.
Sometimes when the senior sit next to a junior, they may be afraid.
I was sitting in another room, that's right.
Yes.
Oblige.
May it please your Lordship. Lordship, I am appearing on behalf of the respondents 1 to 4, the state respondents. I seek your Lordship's
This is a matter which came up.
Lordship's indulgence to accommodate me for another 10 days for filing the affidavit, your Lordship.
Yes. Writ appeal.
It's a PI.
Public interest
It
litigation.
is a PIL, your Lordship.
Yes.
Item number 4.
Yes. How is the writ petition maintainable, madam, in service matter?
May I please,
Yes.
Lordship? I appear for
We
the
are the
petitioner.
petitioners. I am for the respondents.
I appear for the
You are the
petitioner.
respondent, yes.
My lord, my humble submission would be, my lord, what has happened is, in the year 2010, a notification was issued prescribing certain statutory requirements for minimum qualification of teachers. Pursuant to that, my lord, that notification, as well as the condition that there is a mandatory condition, was upheld both by the writ court as well as the division bench of this court in the year 2002. And hundreds of teachers across the districts who did not have that qualification were, my lord, terminated.
That is right, sir.
Now, if I may just
How is writ petition maintainable in service matter?
Lordship,
There is a judgment of the Supreme Court on 3rd November 2023.
Lordship,
Pratap
if I
Singh
may-
case.
if I may just submit, my lord, we are relying on the judgment of the Honorable Supreme Court in the case of Haribansh Lal versus Suresh Mahato, which was reported in, my lord, 2010, 9 SCC 655. To the extent, my lord, that if the
So going
appointment...
back 2 decades ago.
No,
We are quoting giving you the latest citation.
I completely, my lord, understand, my lord, what is the...
Writ petition in service matter.
Are not maintainable.
Permits of YFC
Here, my lord,
is not maintainable.
we are asking for a writ of quo warranto on the ground that the appointment...
No, you have not asked for warrant.
No, we have asked for we are challenging the appointment on the basis that it is
not warrant.
devotes the statutory rules, my lord. The person
Warrant
occupying
against whom it will lie?
the government of the public office, my lord,
You have filed a warrant against an officer.
against the teachers, my lord,
Then
who are holding the public office without without having the statutory, in adherence to the statutory norms, my lord.
By using a different terminology, you cannot seek relief in PAL. If any erroneous action or thing have been done, the aggrieved person will have to challenge it.
If I may please, my lord, at this stage, since, my lord, the notice was issued, they were required to file an affidavit. They were required, the state, my lord,
They are required to?
they were directed by the last order to file an affidavit on the, because they had
Not
taken
required. No, you have to please, you have to convince us.
No, I'm not, well, I am trying to say, my lord, that my ground is that these appointments which have been made are the statutory norms, my lord, and the mandatory qualifications as per the Right to Education Act. And those appointments, my lord, since I'm challenging in a PIL, are maintainable in view of the judgment of Harivansh Lal, my lord.
Where is the judgment? Give the judgment. Who are you?
I am a resident of the concerned district, my lord.
Resident of?
Of the concerned East Garo Hills district.
Why? Huh?
My lord, I am a resident of the East Garo Hills district, which is the subject.
What is
of-
your locus?
I am just a resident. I have no personal interest, my lord.
Then
As a PIL, my lord, I have.
PAL can be filed by anyone. Not with regard to recruitment, with regard to teachers or appointments. There is no writ petition not maintainable, sir.
I have taken that point also, Your Lordship.
You have taken that point.
Yes,
Where have you taken the point?
No, I mean in my draft, Your Lordship, I've already prepared a draft, but I'm
Where is
just,
that?
the draft is with me, Your Lordship,
If I may humbly
and
submit, my
I've
lord,
also got a citation with regard to that.
Let them
that
file the
service matters PIL are not maintainable.
What?
This is of 2020 SCC, Your Lordship.
20?
2020, of the year 2020 SCC, Your Lordship.
I am aware of
Jagdish
the-
Prasad versus State of UP.
at this stage, my lord, my humble submission would be let them file a very short affidavit. Even it may be.
I am only handicapped because I don't have an admixture.
See, you are the petitioner. You have to convince us. When we say that the writ petition is not maintainable, why should I ask them to file a counter?
No, I bow down, my lord. My only difficulty is, my lord, today I am not carrying all these citations in support of my contention on maintainability. Lordship may have it.
Recent judgment which we have worked out and taken at yesterday.
I'll go through that also, my lord. And we'll try to satisfy, my lord. Let this issue be left open.
You take a chance. Let the agreed party file a challenge. The agreed party can file, is it not? Agreed party can file and challenge the recruitment of persons. That is all. You are the
I
locus.
understand, my lord. Let me just satisfy on. Kindly give me one date, my lord. Today it was listed for the orders because on the last occasion the notice was issued. This point was raised in all the three previous hearings before the honourable.
But now she has taken a plea in the counter.
No, the counter is not yet
That
filed.
doesn't matter. Now she is verbally making the statement.
And I've
So
got
court
a
is also
citation.
posing the question.
No, I understand, my lord. So, which is why I'm saying, my lord, that today I did not inadvertently carry the citations because I was under the impression that they'll file the affidavit. Lordship, I have it next week. We'll try to satisfy on this. Only on the point of maintainability first, my lord.
Not on maintainable. But we are of the view that it's not maintainable. It's going to be our order.
I bow down, my
On
lord.
whether it's Friday or Tuesday, it doesn't matter.
Lordship may give me an opportunity. Let me just, I'll attempt, my lord, to try and satisfy your lordships. Just today, unfortunately, I could
One
not.
other judgment is also there. I'm not able to recollect it. That judgment is referred to in that Pratap Singh case.
Lordship may give me, my lord.
You have to come prepared. You can't expect us.
I understand, my lord.
You are making us to read and come and.
No, no, but that is, I bow down, my lord. Lordship may give me just a few days' time, my lord. I'll try to satisfy.
Tuesday.
In the meantime, if they file the affidavit, I'd be a little in a better
You
position.
also
about it.
file an affidavit. They're not going to record. You want to file an affidavit. You will have to convince this court.
Absolutely. I'll try my best for that too.
So in the citation, sir. There's a number. Well, at the request of the petitioner, this court posed a question as to how writ petition, a PAL, in a service matter is maintainable. So, though we are of the view that in view of the recent judgment of the Supreme Court, referring to earlier judgment of the court that writ petition is not maintainable, a PL is not maintainable. In order to give an opportunity to the petitioner, matters to be listed on a registry direct to list a matter on Tuesday.
So in the
What
meantime,
is the citation you have, madam?
20 of the year 2020 SCC.
If the bar is agreeable, both my brother and I can take up all the service matters.
I beg your pardon, Lordship.
If the bar is agreeable, but you will have to forego one round of appeal. All the writ petition can be taken up by the bench, service matters. There are 848 matters pending in this court.
Most of the
As on
matters there are
31st
service.
January, out of that, 93 are only before the bench, remaining are before the single judge. Out of the remaining matter, 848 minus 93, 272 are service matters. So we have taken out the data. If the bar is agreeable, we can list all the service matter before the division bench. So we can give a quietus to the matter. But we will cross first stage and second stage at one stroke.
Lordship can also take it up in
Huh?
the, sitting in the single bench also. If
Yes, there was a precedent is there.
Lordship.
When I think Justice Venkatramaya was the Chief Justice of the Supreme Court, they requested all the High Court to have a division bench for labor matters. So at that time, Justice Naina Sundaram and Justice Billy, and Justice Srinivasan and Justice Janardhan were sitting and hearing the writ petitions. So writ appeal was given go by. Where matters were pending for 10 years. So also we can give a quietus to the matter. I can reduce the number of cases. Probably would have filed a case against the charge sheet. Would have filed a case against suspension. You would be drawing 50% substance tolerance or 75% substance tolerance. Why should that matter be kept pending?
Yeah, most of the matters are service matters, in fact. Most of the matters are.
But they're not very old, not as old as 10
Yes.
years.
Anyway, I'll ask my brothers and all the bar members for a meeting so that we list the service matters. So we can give a quietus to the matter. Previously, the Central Administrative Tribunal is there. Central Administrative Tribunal matters will go before, service matter will go only before the division bench.
Then this matter, your lordships, will be taken up
Give me
only.
the citation, madam.
I've
Give us the
given-
citation.
I just had one copy, your lordship. I've handed it over.
No, just we load on the citation so it will be easy for us to read. 2020 SCC online, Allahabad, 1411. You are having Allahabad judgment.
No, that's SCC, your lordship.
No.
SCC
It's the
online.
SCC online.
Oh.
The judgment of the
Allahabad.
Allahabad High Court judgment, not the Supreme Court judgment.
I'll get it, your lordship.
Which judgment you are referring to? 2010?
Lordship,
That was
2010, 9 SCC 655, my lord. Titled as Hari Banslal versus Sahodar Prasad Mahato.
The judgment on the point is Duryodhan Sahu,
And
1998, 7 SCC 273.
obliged.
Even as regards the filing of public interest litigation, court has consistently held that such course of action is not permissible so far as service matters are concerned.
It's finally.
I'll try to satisfy on this limited point. If
In 2023, they have referred to this judgment, Duryodhan judgment.
I'll go through all the. I'm much obliged. I'll just go through all that. Lordship, I have it on Tuesday.
Duryodhan name appeared to be a villain name, but yes.
Then, Your Lordship, on Tuesday, we'll just hear on the matter of maintainability, Your
Yes,
Lordship.
yes, we'll.
I need not file my affidavit in the
No,
meantime.
you file your objection so that
Okay, Your Lordship.
we'll pass orders also. Even if it's one paragraph, that is enough.
Okay, Your Lordship.
By reserving your liberty to file your counter, on merits you take the point of maintainability.
Okay, Your
If
Lordship.
it's not maintainable, we'll close it.
Yes.
If your matter is going to be kept pending, you'll be losing.
No, this was in fact.
Honestly, we are telling you that we are of the firm view that writ petition is not maintained. That
I
is going to be our judgment.
see, my lord, what is falling from the court.
Yes.
Much obliged.
Obliged.